Christopher Harris.
Yes, Your Honor.
And
I filed a motion requesting a bond. He's on.
This hearing starts calm, but don't blink because it escalates fast. We're dealing with a defendant already on deferred probation, a judge who's clearly running out of patience, and a checklist of alleged violations that just keeps growing. From new felony accusations to curfew violations, unpaid fees, and questionable living arrangements. This case is a perfect example of how quickly probation can turn into a prison sentence. The big question right now, is this a misunderstanding spiraling out of control or a defendant testing the limits of the court? Because as you're about to see, Judge Stevens makes it very clear probation is not freedom, and the margin for error is razor thin.
terroristic threat, burglary of a habitation, failing to perform community service, being at a location after the curfew, failing to pay assessed fees. What else can go wrong? And then this is a new third-degree felony. So you're on probation. This court allowed you deferred or unadjudicated probation on May 29th. And just a few months later, here we are again. And what are you asking?
I'm asking that a bond be set on the, it's our understanding the terroristic threat and the burglary, our understanding is that we don't anticipate those cases to be filed because he was residing at the home. But we will need to address the evading at a later date, but we are requesting a bond.
So what were you saying about he lives where?
He was residing at the home where they're alleging the burglary.
Which is where?
With his girlfriend.
Which is what?
Yeah.
I'm not familiar with the number, but it's a big base.
You don't even know the number.
It just moved there.
Yeah, I thought you were living at LaSalle.
Yeah, I live, but we.
Okay, how many places do you live at?
We'll spend nights at her house and she'll spend nights at my house. When we was together.
Does a probation know he was moving around? He had different residents? You didn't even know that? Thanks. You're on my watch. And you're doing your own thing. You're on your rules. You do it the way you want to do. You're under the directions of this court. Do you understand that? Speak.
Yes, sir.
Thank you. You're looking at 20 years in prison. You want to flirt with that by acting irresponsibly?
So,
Yeah, you do. So we're judged by the actions, not the talk. Anybody can talk. It's the actions, our actions.
This is the moment where the tone of the hearing completely changes. When the judge reminds the defendant he's staring down a potential 20-year sentence, that's not courtroom theatrics. That's a legal reality check. Deferred or unadjudicated probation means the judge hasn't entered a conviction yet. But the moment violations stack up, that mercy can disappear instantly. What's especially striking here is the judge's focus on actions over words. Living arrangements, movement without approval, and incomplete probation reporting aren't minor details. They go directly to trust. And once the court feels misled, every explanation after that becomes harder to believe. So ask yourself, if you were on probation, would you treat these conditions casually, knowing everything is being watched?
All right, here's what we're going to do. It's going to be $100,000. He's going to be, he can't have any contact with the complainant. He's going to have a GPS device, so I know where he is at all time. He can't leave his house, which is not going to be at this location. You're not going to stay at this location on Alabama. You understand? Is it Sabine Pass?
Yes.
Finding locations that call to Alabama is where they located his location, where he was.
Which report are you reading, John?
Probable cause affidavit.
Which one? For the
This is
evasion?
the one, this is the one that is dated for, I'm just looking at it for his address. This is the one that was dated for the original case that he was put on probation for.
Well, the address in which the burglary was related was Avenue.
You can't stay there. Then we understood that you were living at LaSalle. At least that's where you're.
Yeah, that's my surgery.
In fact, this is what's ironic is the bondsman that posted your bond on 11/17, November 7th, the day after this, states your principal address is for.
Yes, sir. Yes, sir.
Okay, that's where it better be. Because this was something sent to this court for us to rely on that's under oath.
Yeah.
So it's $100,000. You must stay at home. You can only go to and from work in the most direct route possible, to and from medical in the most direct route possible, and to and from food, acquiring food. You have no contact with the person involved in this allegation of November 16th. And we will have a hearing as soon as possible on this. When can y'all be ready?
Within probably 2 weeks, Your Honor.
I'll give you 3 weeks.
Yes, sir.
We're gonna have a hearing on this in 3 weeks.
Okay.
And court will note here, let's see. Concerned about this allegation of a terroristic threat that was alleged in the motion to revoke probation.
We weren't aware of any, because he was never in terrorist threat. We're not aware.
We don't have any,
We don't file the motion.
it's,
It says it in the-
shouldn't be in there,
the
Your Honor.
motion
I'll,
file.
yeah, we don't have that on there. I'll abandon that. That's, what we have is the evading with a vehicle.
The probable cause affidavit for the underlying offense that he was placed on probation for. This is an event that happened last December a year ago. And that's what somebody must have placed in the motion. Because it is terrorism. It is stating that he had a gun, had 2 bodies already. And he had pointed a gun at the victim's head. All right. Set this for hearing in 3 weeks.
Okay.
Okay. Yeah, that's on the motion to revoke. Tammy.
By the end of this hearing, the court draws a hard line. A $100,000 bond, strict GPS monitoring, house confinement, no contact with the complainant, and a fast-tracked revocation hearing. All signals that the judge is deeply concerned about compliance and public safety. Even more telling is how alleged violations were clarified, corrected, and narrowed in real time, showing how precise probation proceedings must be. This case is a powerful reminder that probation isn't a warning. It's a final opportunity. One misstep, or even perceived dishonesty, can flip everything overnight. Back-end index pointing right if you found this case as intense as we did. Hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal analysis.